Can they do it? No, they can't. It's the simple answer. They shouldn't be doing that.
Thank you.
Right, the other thing I was going to say is that we talked about individuals seeking compensation. Obviously, Microsoft weren't an individual, and Microsoft are a limited company. So the regulations talk about emails being sent to individual subscribers, as we've seen, but there's nothing then that says if you can't claim if you're a limited company. And of course, Microsoft were the recipient of those emails, but still made a claim. But they couldn't claim. That's why they constructed that claim in a way that said, well, you've actually damaged our business, as opposed to for receipt of you've upset us because we've received this email. So they kind of went on a tangent, which is not perhaps strictly within this area of law, but that kind of begs the question, well, if you can't send spam to a company, but as Microsoft are a company, clearly companies can bring cases. So sort of taking that one step further, and I speculate on this, could you see a situation where if you're routinely sending out marketing rubbish to people and which you're not supposed to send, and you're getting work out of it, could that lead to your competitor bringing a claim and saying, well, hang on a minute, I've lost a load of sales as a result of this.
Get spamming.
Exactly. Do I have a claim against you? You've broken the law. You've done a load of illegal marketing. My business has suffered loss. This is how much loss I've suffered. Pay up. Microsoft seems to suggest that, but I can't believe that's right, because I think the problem would be, as a competitor's business, you need to show that there was some sort of. I think you'd have to show there's some sort of relationship between you and that of the business, and I think you might struggle on that. I think you could probably distinguish the Microsoft case on the basis that Microsoft had actually physically received those emails themselves as well. So, and obviously their particular place in the market as being, in that case, the provider of email services, I think maybe leaves that as a case on its own, but it's certainly something to think about, and no one's tried it yet. There is a defence if you do end up accidentally sending marketing emails to people who didn't want them, and that is that you took reasonable care to comply with the relevant requirements. Quite what counts as reasonable care is a good question, because lawyers are very fond of the word reasonable, because we can interpret it in numerous different ways. You've done your best, I think. You did everything right, but it slipped through the net. Enforcement, what happens if it does go wrong? It's the Information Commissioner who oversees Data Protection Act and the privacy regulations as well. He can undertake assessments to find out what's going on. He can issue enforcement notices telling you to do something, and information notices. He can ultimately obtain warrants to search your premises, seize materials. He can also, there are cases where he's ordered deletions of entire marketing databases. So there's quite a lot of stuff that can be done there. He can act on his own initiative or as a result of a complaint from somebody affected by a breach. And can ultimately, has a sort of a statutory procedure whereby he can take you to court, or the equivalent.
Is that local to an area? So for example, we're receiving emails from someone overseas, who would we take that to?
I would go, well, yeah, I mean, it's in the first instance, report to the Information Commissioner here in this country. Ultimately, the answer probably is it depends where it's coming from.
Would the Information Commissioner, would they have expected the person to have made a complaint first, i.e. said stop sending me emails, before they took it to the Information Commissioner?
Would they have expected that? I think I would always recommend that you do that. There's no reason why you can't just take it straight to the Information Commissioner, but I think if they might just say, you might get the response, well, why don't you just say, just ask them to stop. There's nothing specific that says you need to do that, but I would do, yeah, I think. Just a brief mention, there's a parallel sort of jurisdiction in the Advertising Standards Authority, who actually do take regular enforcement action against, it's the same organisation that enforces TV adverts and such things, but also covers here unsolicited commercial communication, so business to business, sent by email, and says they have to be clearly and unambiguously identifiable as soon as received. So if it's an advert that you're sending to a business, then under the Advertising Standards Authority, it has to be obviously clear and ambiguous. What that seems to mean in practice is that in the subject line you should have something in there that makes it clear it's a promotional advert of an email. There's quite a lot of adjudications that go on all the time on this sort of thing. They tend to be censuring businesses that are sending marketing emails, again, without prior consent, and also for failing to make clear that it is a marketing email. And finally, a few helpful hints. Just a few sort of a resume really of what we've talked about. First of all, the key one, if you're going to do marketing by email, just get consent, because if you've got consent, it's nice and easy. Get a positive tick box. Yep, thanks a lot, I'd like to receive your marketing emails. Give them a chance to unsubscribe every time you send an email. You won't go far wrong. You're collecting information about people, state how you're going to use it when you get it, rather than having to sort of play catch up later on. Just tell them this is what I want, this is why I want it, and I won't do anything else with it. Don't go around pre-ticking boxes. I don't like that at all, because it's clearly an attempt, and the court won't either. It's just an attempt to get around the fact that you're supposed to have an opt-in. But you'll pre-tick it and then say, oh look, I had a tick box and they had to tick it. Well, no, you've ticked it already. It's an opt-out. So it doesn't work and it won't work. So don't do that if it is something you thought of a clever way around. Just provide an easy method always for your user to say no to something. I know you don't want to do that really, but if you've got to give them the opportunity. If they don't want to receive your emails, ultimately they're probably not going to buy anything off you anyway. So you're probably not really losing a sale. If you do get an opt-out request, comply with it immediately. It comes back to something we talked about before. Again, if you don't do that, Information Commissioner, if you complain to him, can come down on them and you might get some cash out of it, particularly from Harvey's Furniture Store in Stand. If you're doing the marketing, and things are occasionally going to slip through, even the best of us, you're going to make mistakes sometimes, have a complaint system in place to cope with any unwanted marketing. So if you get a complaint in, an email that's been received, you've got a process ready to go. Here's how you're going to respond to it, rather than sort of faffing about and taking ages, because that's just going to cause the complaint to spiral. And then they might get the Information Commissioner involved, which if you're doing lots of email marketing, you don't want him investigating, because you might find other things that perhaps you weren't doing as well as you might have done. And the final one is a tip on the same sort of lines. If people are saying they don't want to receive your emails, rather than just deleting them off your marketing list, have a way, probably a tech way if you like, of suppressing them rather than deleting them. Because obviously the problem if you delete them is you might pick up their details again from somewhere else later on. You then haven't got a record that they actually opted out. They get added back onto your list, you send them something else the following year. Now they're really fed up and now they make a complaint to the Information Commissioner, whereas before maybe you'd managed to deal with it yourself.
There are ways around that though, depending who you're using to do your email marketing. We won't let them opt back in again.
Yeah.
You manually, as we do it, and we lift them from an Excel database, but we don't have to worry about taking them off the database because it's automatic. We won't lift them off it once they've opted out.
Right.
But it depends who you use it.
Yeah, and the other thing that I'm not sure how it would be is if you've got, I'm not sure if there are any cases on this, whether it's the same person but with a slightly different email address. That you've got to be a little bit careful with that as well. I suspect you'd probably get away with it if it was clearly different, or if it was not obvious that it was the same person. So if it's a very different email address, or if it's something like, I don't know, you're never going to know, or asmith@hotmail.com or whatever. If it's something very, very general, you may well not realise that.